We'll get going on where we left off. So again, what we're talking about right now are the rules that apply when there is no will. So if there is no will, this is how property is going to be divided. Under APRA, your land is going to be divided into two categories. The interests in the tracts, where you have a share that's equal to 5% and above, where the decedent has a share that's equal to 5% and above, an interest of less than 5%. So they're treated differently if it's more than 5% or less than 5%. That 5% is determined by the amount of share in the property. It isn't based on how much that income is from that property or the size of the acreage. So you could have a 10-acre plot or a 160-acre plot. If that's the property that's the undivided interest, it's going to be 5% based on that. So for those shares that are equal to 5%, 100% life estate without regard to waste, and we'll talk about what that life estate means in the next slide. But if the person is married, their spouse will get a life estate in that property without regard to waste. After that life estate, the other eligible heirs take a future interest in equal shares, and it goes down in that order. It goes to children, grandchildren, great-grandchildren, parents, siblings, Indian tribe, and co-owners. So if there are no children, grandchildren, great-grandchildren, or parents, siblings, then it goes to the Indian tribe, and then to the co-owners. If the share is less than 5%, the single heir rule kicks in, and it is a slightly different percentage. So the interest, the less than 5%, are going to go to the oldest surviving child, the oldest surviving grandchild next, the oldest surviving great-grandchild, the Indian tribe, and the co-owners. Under the less than 5% interest, who is not there? So who out of the eligible heirs, because the spouse gets a life estate. The spouse doesn't ever get to be an heir. So out of the heirs, siblings, yes. So on your less than 5%, your siblings cannot take. If somebody is unmarried and their parents have passed away and they never had any children, if it's less than 5%, the tribe is going to get that. Yes?
It's always going to be an Indian tribe, so a co-owner has no chance of ever.
Yes, that's true.
Just wipe yourself off with your co-owner.
So what we have talked about with other tribes, and when we get there, it's something the tribe can contemplate, is that the tribe can change this order or add to it if they get an adopted probate code. They can add the siblings back in there. We've had other tribes that have not adopted a formal probate code that's been approved by the Secretary of Interior. But what they've done instead is have a really active, where they relinquish their right, like they relinquish their right to heirship. So you'll have family members come in and say, hey, we have this less than 5% interest, but it's really valuable, profitable land that has a lot of resources on it. Tribe, we'd like you to abdicate your interest. And so then let, like a siblings are, because a lot of times siblings are then co-owners, and then they would get it from that perspective. It is important, it's important that people do this really, really early on, because this is only possible during the probate process. Once the probate closes, those transfers of land are permanent, and then those other rules that apply to sale and transfer kick in. So, and so the issue that happens with Indian tribes is once the probate closes and it's transferred to an Indian tribe, what is the rule is Indian tribes cannot sell land. It's in trust. The only way trust property for Indian tribes that they can dispose of Indian trust property is through an act of Congress. And so that's why if you as a family member know of a interest where a will wasn't written and it's less than 5%, but your family's still interested in it, you're going to want to talk to your tribe early on, especially if your tribe doesn't have a formal process. Like I said, we have some tribes that have a fairly developed process to address this, outside of doing a whole probate code where they have an application form where you put in and say, we would like you to, pass on your interest in this, in the probate, and they'll have that filled out and it'll be ready for the probate court. But if you don't pay attention to it and it goes through probate and the probate closes, it belongs to the tribe and there's no way at that point for the tribe to relinquish their right once that title has been conveyed. So that's really time sensitive. Yes? What? Oh, okay. So you got a letter of administration from OHA, like from the Office of Hearings and Appeals? Okay. A letter of administration. So without, so what we would probably need to do is meet with you individually and take a look at that document. So talking about, and we get into this a little bit later on, like in terms of probate. So tribal people, tribal individuals may be in multiple probates. There might be multiple courts who have an interest in what happens when that person dies. So because of the way that the law is written, OHA or the feds have they have the exclusive authority over what happens to trust land. However, they don't have any authority over like fee land or deeded land, non-trust. And so you may have somebody who owns like fee land and trust land, and you're gonna have two different courts who may have authority. And so it could still be a legal document, but it may not have the same application in those two different courts. So there's a lot to work through. It's always going to be very case specific based on what the type of property is, what the court is saying, and what that document is. So in terms of a specific situation, we're talking about generalities. To be able to answer a specific situation, we'd have to look at those documents and know the underlying facts and status of the property. Again, it's hard for us to answer without really looking at those court pieces, because there's different courts that have different jurisdiction over different pieces of somebody's estate. So without sitting down with you, going through it and looking at all of those papers, we just can't say from the summary of what you're talking about.
Lisa. Lisa, say something?
So could you explain? So, you just want to know if that AOL is good or not, right? Okay, so we are here just to put on a training for the people to empower them about as landowners. So we're not here to give legal advice or to determine if the judges were right or if they were wrong or whatever. So we're just doing a training on land to empower landowners. Yeah, so that's what yep, but we're not here to represent landowners. We're just here to give them information to help, just as a landowner. And not to represent anybody or to, look at court cases or anything like that. This is just a training. So they could explain to you what an LOA is. They could explain that to you. But they can't, we're not allowed to, represent people, or we're just doing a training, But they could tell you what an LOA is and let you know if that's a legal document or not.
Yeah. Yep. Yeah, and actually that is something the tribal court does have jurisdiction over. The tribal court has jurisdiction when a person dies for someone to go in and file a motion to be the administrator of the estate. And your tribal court grants an order. That's a whole proceeding, though, that other heirs can show up and they can basically say they contest that. They're recommending another person, but the tribal court does have discretion to have a hearing and determine who should be the administrator of an estate. And remember, though, when they're administrator of the estate, they're really just dealing with non-trust property. All of the trust property, that jurisdiction is with the Department of Interior, Office of Hearings and Appeals. So, like Georgette said, in a probate, there are different types of jurisdiction that apply and different orders. So that's what that would be. And that's probably an action that could have been appealed. I don't know what the status of that is.
So does that answer your question?
Okay. Well, why don't we keep going and see if there's some other advice we can try to provide? Okay.
So, as we had talked about in the order of inheritance, if there is a spouse and they inherit a life estate, so this slide talks about what a life estate is. So, under the law, under APRA, the spouse will take that life estate without regard to waste. It allows that person, that spouse who inherits it, to receive all the income, including any bonuses or royalties from the land, to the exclusion of the heirs down the line. And then they are able to make decisions on that land while they have the life estate as if they were the full holder. When a life estate is in place with regard to waste, there are limitations on what that life estate holder can do. Those limitations don't exist in this circumstance. So you can have a spouse who fully develops that property and fully realizes that income during their lifetime, regardless of how old they are and how long they have it. So they don't have to think about the heirs down the road. And Nagel's done a lot of work with Reaffiliated, and this becomes a big deal with oil development. So you can have, and she always uses the example of a person who gets married, has a family, and then later in life, they leave their spouse and get remarried to somebody very young, and then they die without a will. And that spouse, whether they are Indian or non-Indian, has full access to that land. That person would have authority to develop that land, to have wells there, and get that money from that would fully belong to her until she passed away. And if she was young, those children of that person could wait a really long time before they could benefit from that property. That's what this means when you die without a will. So people who get married a second time and may want their children to access that property sooner really need to think about making a will.
Right, and so the whole life estate concept, the life estate without regard to waste, is a real radical shift from state law application. Before, when you had a married couple and one of them died without a will, the other one inherited the land. They would inherit the land. So, you have a husband and a wife, and they buy land, or one of them has land, and maybe they build a house, and they develop that and so forth. And when one of them dies, the other one usually inherits. That's under state law. And that's what you all understood. That's what happened here in Indian country. This law changed that. So regardless of who you're married to, whether they're a member of the tribe here, a member of a tribe somewhere else, a non-Indian, they will take your whole estate in a life estate for as long as they are alive. And the kids that you had, or the kids he or she had before the marriage, won't get anything until that spouse that has the life estate passes away. So this is a big change in inheritance. So, did you have a question? A what?
What if the wife was a white person? Would she still be entitled to the tribal land?
Yes.
She would?
If you have a tribal member or an owner of the trust land, and they marry a non-Indian, a white person, if they die without a will, that non-Indian holds that whole estate while they're alive. And the Indian heirs down below are waiting for that spouse to pass away before they get to own the land. That's how it works. And this is in effect, has been now since 2006. So if you don't want that to happen, you have to do a will. You have to do a will. Right. Okay. Yes. Speak up, Russ.
So, gift deeds.
Yes.
I don't know if we got to that or not. Excuse me, but will the Bureau recognize a gift deed with a life estate? I gift deed to Georgette, but I keep the life estate.
For
Will
yourself.
they recognize that? Yeah.
Yes, and that has become a very common thing. And the reason that that's become a very common, sought-after practice is because of the delay in the probate court. Right now, your Rapid City office shut down, the Billings office shut down, all the probates are being moved to Albuquerque. So it's going to take a very long time for probates to get through. They're very short-staffed. So what a lot of people are doing, my mother included, is to go ahead and do a gift deed right now to all the heirs that, or to all her children that she wants to have her land, and then she reserves a life estate to herself. So she can still keep getting lease money and doing all of those things. But then that's recognized by the Bureau, and then upon passing, you know, you already own the land. You don't have to go through the whole long probate process.
So that's similar to what's called a transfer on death document.
That's what you call it under state law, is transfer on death. It's, in Indian country, we use gift deeds. We use gift deeds for lots of under-table stuff too, but this is one way to convey your property and hang on to that life estate. So it's an estate planning tool. Yes?
You could get your own attorney and put a will in place, or would you still have to do it with the BIA?
No wills at the BIA. The BIA quit drafting wills in 2007 or 8. The reason they did that, though, the reason that they did that is a lot of the wills that were done across Indian country were wills that used a form. I don't know if you all remember. They used to have a form that you would do a will on at the BIA, and it would list all your heirs. And a lot of times that will would say to all my heirs to share and share alike. And they said that these wills weren't stopping fractionation. They weren't controlling this fractionation if you just say to all my heirs to share and share alike. That meant to take every interest you had and cut it up among all the heirs. So that was a problem. They were trying to end fractionation, and so they discontinued. The other thing that there is a lot of factual evidence to prove, they lost a lot of wills. They misplaced wills, and that caused a lot of chaos. So in 2008, there was a policy that the BIA would no longer help you with the will, and they won't hold your will. They won't store your will. So you have to figure out how you're going to store your will. I think the legal department will do wills, and they can store a will. Private law firms can do a will. They'll hold the will. We have lots of wills that we've done, and we hold them for people with an instruction on who should receive it afterward. So that's the way that the will business works today.
Okay. I went to court, and I had my mother made me a will. I went to court with my older brother, went to court, civil court, and he had a professional attorney from Rapid City, so we went to court, and my mom made that will, signed it. My brother about fell over in the courtroom, and that professional attorney didn't say one word because she had a will in place with my name on it. And I also understand that the tribe, if you just don't have too much land, fractionated land, that they take it back. Is that true?
Well, what is that?
Like if you just have not too much land, like half an acre or 2 acres.
If you have really small interests in land, the tribe can try to buy it from you at probate. However, the tribe's never done that. As far as we understand, the Oglala Sioux tribe has never showed up at probate to purchase any land. But they would have to get your consent. You would have to agree, and you would have to get fair market value. It's available, but this tribe hasn't moved forward with that in an active way. Right, Russ? Am I correct? Yes.
So there's the tribes, BIA, they're set in place the dollar amount that they want to buy from you, but you could up the price too.
Okay. Where are you at, Georgette?
We just finished life estate.
Okay. Okay, but before we move off, while you're talking about wills, let's just really quickly talk about wills. When you're going to do a will, all of you, when you're going to do a will, there are some rules that you have to make sure. We just heard yesterday by a guy who said he had a will, And then we talked about what the standards are for an Indian will. And he said, oh, my will doesn't meet those standards. And I said, okay, if it doesn't meet these standards, then it will be set aside. So when you do a will, first of all, you have to be over 18. You have to be of sound mind. And you have to be making this will by your free will. In other words, no one's telling you to do it. It's your free will. You also need to know your bounty. It means you got to know what you own to do a will, to do a knowledgeable will. What is it you own? You got to know that. And it doesn't have to be specific by land description. You just know that you own trust land on this particular reservation. That's sufficient. Then you also have to know your issue. That's your children or your heirs. You know your issue. So those are real common requirements. Then, when you go to do your will, there has to be, you have to watch, you, the one who's doing the will, you have to have 2 witnesses. And those witnesses have to be disinterested witnesses, directly or indirectly. So if you have a niece there who's going to be your witness, but you're leaving something to her mother, she's going to benefit in the long run. So she would be receiving an indirect benefit from that will. You can't have that. You got to have 2 completely disinterested witnesses who are never going to benefit from your will. And when you sign, they got to watch you sign, and you got to watch them sign. And then you got to have this third person over here, which is me, usually, and I do an affidavit that says I witnessed these witnesses signing the will, and I witnessed the decedent signing the will at the same time. You put that in an affidavit. That's very important. If you don't do that, the will's going to get set aside. You got to have 2 witnesses, disinterested in the will, and everybody has to watch each other sign. And then if I drafted the will, I'm the scrivener, I'm the one who put it all together as the attorney, then I do an affidavit that says I watched all these people. And then these witnesses, and Georgette and I have done this. We've done this. Georgette's in the room there. And then she will ask the decedent what?
So I'll ask you, hey, what's today? Do you know what day it is? Do you know who the president is? What season is it?
What town are you in?
What town are you in? We had an older Crow lady, and I said, well, do you know who the president is? She sort of looked at me and laughed, and I said, all right, well then, who's the chairman? And she could answer that. So I have to know that that person has their mind, that they're competent. So when I'm witnessing, I'm not just, they can't pull somebody off the street who says, oh yeah, I saw them sign something. Well, what did they sign? I have to say, what are you signing? Do you know this is a will? The witnesses have to know what's being signed as well.
So you both have to know. And that's very important because you will have, once you do all of that, you have your witnesses, the ones that are witnessing, they need to ask questions. Because when there's a will challenge, if somebody says, well, hey, that person was on morphine, or that person really was not in their right mind, then the attorney will have to put Georgette on the stand. And they'll say, you witnessed that will. Why do you think that person was competent? And then she can say, well, I asked these questions, and this is how I made that determination. That was also another thing the Bureau didn't do. And I had plenty of cases where I put that BIA worker on the stand, and I would say, how did you know this person was competent? What questions did you ask? And a lot of times they ask no questions, way back. And so these are things that we have learned the hard way in court. So this is sort of the practice that we utilize for those wills. Yes. Oh, yes.
So my oldest sister passed away. So what I understand is I'm the next oldest, the eldest. So in our probate hearing, we spoke to the judge on phone, and we had a conference. And so
we had that done, and then, but he contested, he counted, so then it wasn't complete. So he made some other statements on it, so then we had another, I guess we had another hearing, so the judge went over it. And so we all got letters again, he sent us letters, and same thing was in there, what that probate hearing was. The same letter that the judge signed, we got that letter again. Okay, so it wasn't final, I guess, because he contested. And so we got another letter from the judge, and he contested again, saying that we beat up our mom, which never happened. So anyway, so that happened, so he contested, but that didn't happen. And so then the whole reason why we got that letter he's talking about Alloway is because when our mother died, he wasn't around. Nobody could find him or the other sister. And that we were supposed to be taking care of her. When our mother was dying, those two weren't. They couldn't find him, no phone numbers to call the emergency. It was an emergency. So when they contacted my other sister over here, the one he's talking about, Mary, she called on Joyce and told Joyce, so we all got over there. But our mother was dying and they weren't aware of it. So anyway, so one of us had to step up and get this LOA. And they said it has to be the oldest. But I didn't want to do it. So I told that time I was sick. So I told Joyce, I said, you go ahead and do it because she's next after me. So I could get this LOA. So she did. She went to the court and she got that LOA. Just for the arrangement. Just for the arrangement. That's what it was, this LOA. And they granted it. The judge granted it for that. Okay, so that happened. The funeral was over. We buried our mother, and then that was done. Okay, so then we got another letter. And so now the judge saying that we have to get a final letter, which we're going to get soon here. We're going to get that. And then that's it. It's done. It's over with. And so the judge told us when we had that hearing, he said, who's the eldest? I said, I am. He said, okay, you're going to get the shares of your mother, the little shares that your mother has. You're going to get those. But our other land that we have is 365 acres. That's undivided, so that's going to split between 9 of us. So we're going to split that. That's how the judge explained it to us. So, but the little portions that my mother had, the eldest child gets that. So that'll be me. Yeah. Yeah. That's how he explained it to us. So that's how I understand, and that's how we all understood it. But he's the youngest one, so maybe you don't understand those parts, but that's how it is. So now my question is, if something should happen to me, who's going to be next to get my mother's land? Who's going to get that? Yeah, the little interest, yeah. Okay, so do you think I should make a will? know how to click on it. So where do I
So,
go for,
I-
where do I go for, to do a will? Whose office do I go to do a will?
Who do you go to do a will?
Yeah.
The legal department has a program where they are going to provide a will drafting
Where's the legal
service.
office at?
Pardon?
Where's their office at?
We're located at the old bingo hall in Pine Ridge, there's a whole box of factory. Like that. And I just wanna add to the whole will thing. And how important it is to have a will written prior, you know, like way ahead of time, because, you know, life is just very unpredictable. You know, you could be here one day and one day you're not here, you know. And so it's really important for you guys to have that will. But like the attorneys are saying that, you know, if you have land, that it becomes so unfractionated, you know, it becomes fractionated, and so it just just splits everything up. And not only that, but your wishes are laid out in your will. And so it kind of eliminates some of the bickering and fighting amongst family members and stuff. But then on the other hand, it might cause friction, you know. But anyway, we do wills. Anytime, give us a call, and we set up an appointment with you. And then Russ, he had to leave right now, but at the old Moccasin factory or the bingo hall up in Pine Ridge. Yep, OST Legal Department. Our phone number is 867-2138. And if you can't make it, or people can't make it to our office, we come out to visit you also. Yep. Lisa? I'm from the Rocky Ford. She used to do wills for the tribe. Like, I don't know how many years ago. I've been at the legal department for like 13, 14 years, and it was prior to that. And I don't know, did we talk about probate, like, the BIA probate?
I mentioned that.
Yeah, so when they did wills and they closed their office down, she took her wills over to the BIA probate. And so I don't have any of the wills that she wrote. I have some of the wills that Russ Zephyr wrote, but all of our wills that we do for the people, we either give you the copy or give you the original. It's really up to you. And then we keep them in a fireproof safe in our office. And we let BIA know that we have a copy of the will or the, you know. And I don't know where she's at now. She doesn't work for us. Yeah. Yeah, I don't know what yeah. Okay, yeah, just give our office a call or stop by anytime. Our office are 8 to 4:30. And yep. Yeah. Yep. Yep. And
So-
then you have to, like, one of the qualifications or the requirements is that you have to be competent
Yeah.
to sign a will. So if you're not competent, we can't
Yeah.
notarize your will or anything. So it's very, very important that you know, do one, you know, so you're able-bodied, you have your wits about you,
And Lisa, oh,
so that would be your responsibility. Yeah.
So I don't know if there's really anything that we could do for you, Irene. But anyway, I no disrespect for you, but to be respectful to the other people that are here for our training, we would like to move on. And I don't know what to tell you.
You have a will from
Is it still good?
86?
Is that what you guys were saying, that we have to have new will, and these ones that are with the DIA don't count anymore?
A living will. Okay, so what we are saying is that the law changed dramatically with APRA, and they changed some of the ways that you could leave your land and what would happen. So it might not do what you want to do. We would suggest that you do have it looked at again to make sure that it achieves what you want to achieve.
And I guess what I would add, and we didn't talk about this at all, and this is a good time to bring it up. Before I get there, though, I do want to say, no disrespect to you at all, but I will say, I have dealt with many families who thought that they were all very close, and they all got along, and they all thought the same way. When there is a death, that changes. And you can have people who are very close all their lives, and everything changes. Whose fault is it when all that trouble happens? Whose fault is it? It's the decedent. They need to take care of these things ahead of time, unfortunately, and that's a real hard. And I'm dealing with families, some families. I was telling these guys that there's people at Fort Berthold, they have millions of dollars at stake. Enough money to take care of a whole large group of, family members, and they're in a war, horribly. And finally, you have to say, stop blaming each other and think about how this happened. And it happened because the person who had all of that land or had all of that didn't have an opportunity to do a goodwill to keep the peace in the family. So that's a really hard thing. All right, so I just say that, and I don't mean any disrespect at all, but I just offer that because I've been in the middle of these court battles for many, many years. And no one is happy in a court battle. Nobody's happy. There's one way to come out happy, and we're going to tell you about that later, and that's through a settlement. You can try to do a settlement, but you all have to be in agreement too, and we'll talk about that. But in terms of your old will, I would really take a look at it, or have an attorney take a look. And here's one of the reasons. Before this law, before APRA, if you left your, yes.
Some of us know about this. The fractured land, my grandpa made his will. The land was very important to him, and he gave certain everyone's to certain, and so that went well, but he was married to an Indian lady, and then it come down the line. My uncle, he made a will, and who else? My mom made a will. And now we're going to go through another will, and we have no problem, I think, because they're all married to Oglala Sioux Indian
Yes.
women and men. So I think when you marry into a non-Indian, that's when all trouble begins, I think.
Right. Well,
Yeah.
see, that's good planning.
Keep it in the family, the blood column.
Right. That's
Yeah.
very good planning. So that's what needs to happen, and that's hard. But I do want to tell you, before this law, if you did a will, and say you had the big interests, the interests that are larger than 5% or whatever, big interests, and you said, I'm going to will my land that I own to my 3 kids, you have to say, I'm going to will this land to my 3 kids as tenants in common. Where's Russ? Because they have to be tenants in common, because when you own land, if Georgette and I own land as tenants in common, if we own that land in undivided, tenants in common, if I pass away, my kids get my share, okay? But you have to say tenants in common. You have to say that, because if you don't say that, the new law says that when you will your land to more than one heir, they will take it in a joint tenancy with a right of survivorship. That's what the law says. So what does that mean? That means, like, if Georgette and I own that land together and the will didn't say tenants in common, then there's naturally it will be treated that we are joint tenants with a right of survivorship. That means when I die, my kids are cut out and she takes my share. Yeah, this is a a lot of people are not aware of that. So when you do a will, unless you want a joint tenancy with a right of survivorship, maybe you want that, and some people do, because it does stop fractionation. It does. It does stop fractionation, but if you want 2 to own together, you better make sure you understand it's got to say tenants in common. And that's another thing that probably is not addressed in that old will, because the law was different then. There was a presumption for a tenants in common. Now there's a presumption for this other way to stop fractionation, joint tenancy with a right of survivorship. So that's a really good reason to take a good look at that will, or have somebody look at it for you and maybe go through it. Okay. All right, we're going to keep going here. Where were you?
All right, we were at IAM accounts. So,
Did you talk about where the tribe could renounce?
yes.
Okay.
I did.
All right.
Yep, and we talked about how the tribe could add to their probate code for that if they
Yes,
wanted,
okay.
but until a probate code, you could ask them to renounce.
Okay.
So, when you die without a will, as you know, probates take a period of time, but somebody may die and still have money in their IAM account, right, if they're getting income from that. When you die without a will, your IAM account there's very specific rules on how that IAM account is going to be treated. So, if you are married and you have eligible heirs other than your spouse will get 1/3 of the income, and then the remaining eligible heirs will split the other 2/3. If you are married and you have no children, your spouse will get all of the money in that account. If you pass away and you don't have a spouse, your eligible heirs will get it in an equal share. So that's set by the law.
Before we move on, yesterday there was a big question about common law marriage, because, this whole spouse issue is very critical here. So Oglala Sioux tribe does have in the tribal code a recognition of common law marriage, and there's some criteria on how to establish that. However, the APRA, the American Indian Probate Reform Act, does not recognize common law marriage. They want you to have an actual marriage license for all of these transactions. I say that, but I also have a case. So in Montana, you better be really careful when you go to Montana, because you can form a common law marriage like overnight. It's very easy to have a common law marriage in Montana, and there are some criteria, but it's easy to do. So we had a wife show up in a probate and she said, we're married under common law. And the judge said, well, we don't recognize common law marriage. And she said, but we didn't form the common law marriage on the reservation. We formed it off the reservation, and it was recognized by the state. So I want you to recognize that common law marriage that I created under state law. And the doggone judge did it. So. Yeah, they recognize that that common law marriage had been created in another jurisdiction. That case is on the books. I don't recommend trying that because you never know what kind of judge you're going to get next.
But she already had a court order recognizing it.
She had a court order recognizing her common law marriage in another jurisdiction. So that's a little bit on common law marriage. Well, this jurisdiction of OHA is particular to Indian lands. So I don't know if we could make that argument.
I
Yeah.
think probably also what benefited her was she had gotten that formally recognized. So once it's formally recognized by the state, it's a marriage, right? Like normally people aren't trying to get their common law marriage recognized until divorce or until death. She had had an issue before where she had had it recognized and declared. And so that may just be the distinguishing thing rather than then being in the middle of a
Right, but however, there's a lot of people that claim to be common law married when they're not. And you know, because look what they can get. You can get a whole life estate, 100% in something. You came in and said, you know what, I'm really married to this guy under common law. That's why they're not going to do that, because it, you know, obviously it would be very complicated.
But,
yes.
But it does go back to our original statement, which is if you have trust property, if, again, when we're talking about who causes all these disputes to happen, right? Like if you want something to happen a certain way and minimize the conflict after you're gone, the best way to do that, and the person who has the opportunity to do that is the person who's writing the will, the person who can do the will, right? Like, so like I have a family member who has a very contentious relationship with her stepchildren. Her husband has made very clear the will that he's going to do, right? Like, so he's done a will because he knows that's going to be an issue. The one thing he hasn't done, and I can't make him do it, but I do recommend to my clients, and my mom did it, is as hard as it is, she sat us all down and said, this is how I'm going to do the will. You may not think it's fair, but this is what's important to me. And she had us all together. So we all heard it together, and she said, this is what I'm doing.
Or you could do like my mom, and she said, it's all over with. I already gift deeded what I'm gift deeding to all of you, and it's over, and I'm keeping a life estate, so leave me alone. And when I'm gone, it's done and over. So that's another way that you can do estate planning, is to do gift deeds. And you can gift deed, you can think about how to deal with your after acquired land. So. Yes, yes. And let me talk to you really quick about, yesterday the BIA was in attendance at our meeting and on gift deeds. Because gift deeds, sometimes, as you know, the BIA takes a very long time to approve things. They will take a long time to approve different things and get them recorded. So what happens a lot of times is, you know, a gift deed may not get recorded and then somebody will die. And there's a question about whether or not that gift deed was valid if it wasn't recorded. So what we understand yesterday from the BIA here is when you go in to do a gift deed, they give you an application and you fill out the application. They go through it, they prepare a deed. They actually prepare the deed that you have to sign. Then you have to go back and you have to sign the deed. Once you sign the deed for the gift deed, you're done. And there's cases that say if you have gone that far and you've done that, even if the BIA didn't record it, it's valid. It's valid, and that land will come out of your inventory, and the title will be vested.
But
You can ask for it, yeah, but what?
all I was going to say is, but people have to remember the difference between the application and the deed. That
It's a two-part process.
Yes, just starting the process, saying this is what you want to do is not enough.
Okay, all right. we're kind of jumping around, but we do want to accommodate your, your questions. So now let's go to another big headache in Indian country. Who inherits the doggone house? Who inherits the house when it's sitting on the trust land? So according to the law, at 2206, it says the house is going to be inherited to all the eligible heirs that are going to own the land. So if you have a house sitting on land and there are 6 kids that inherited that land, they're going to share that ownership of that house in the same way they share ownership in the land. And it doesn't make any difference on that successor in interest that was done by HUD. You may have a difference when HUD gives somebody a deed, a deed for the house, but all they're going to own is the house, but not the land. Yeah, and so that's a real issue, is just, you also have to be aware of that.
You could kick them out of the yard. Well, okay, the person who owns the house just owns the physical house. So the person who owns the land could say, I own the land. I don't know how you think you're going to get to this house unless you drop in an airplane. So owning a house without owning the land around it.
These are no good. We've been involved in these too. Oh my gosh, we have families that fight, and one sister will say, I want you to lift that house up and get it out of here, because the rest of us, own the land. And this isn't gonna, if you want that house, you take it out of here. And, oh God. I used to be the housing attorney at Crow, and it was like, yeah, terrible, yeah. Okay, so we've gone through that. Let's see. All
So
right.
with a will.
Now, who can you will your land to? Who can you will your land to? You can will your land to keep it in trust. You can will your land to any of your lineal descendants, any co-owner in a tract, which will probably be your siblings. And then you can also will your land to the tribe if you're feeling really generous. Or you can will your land to any Indian. You can will your land to an Indian, even if you're not related. Keep that in mind, Lisa. But yeah, you can will your land. So that means you can't will your land to a non-Indian entity. There are rules about that. You have to be an eligible devizee to inherit under a will, and you have to meet one of these categories.
And a non-Indian spouse?
Well, that's down below here. Now, if you have a spouse who is non-Indian or somebody else that's non-Indian, you can try to go ahead and do a will to a non-Indian. But it says that here that the tribe with jurisdiction over the land will have an opportunity to buy that interest for fair market value right at probate to prevent it from going out of trust. So if you have a non-Indian spouse and the tribe gets notice of the probate, they can show up and say, we want to buy this land before this non-Indian takes it. There is a little exception that if the non-Indian is living on the land in the house, if it's part of a family farm, they can take they can take a life estate on that small part of the family farm part. But the tribe can buy out that non-Indian spouse at probate for fair market value. And they can do that, it looks like, without consent. I mean, you can force a non-Indian spouse basically to keep the land in trust by buying them out. On an IRA reservation, which we are an IRA reservation, if you try to will your land to a non-Indian spouse, all they're going to get is a life estate. They're just going to get a life estate. So it won't go out of trust, but they'll just be there during their lifetime unless you adopt a code that says they can have it. But if you don't have a code that says anything like that, they will only get a life estate.
But that non-Indian time of probate, if it comes up and somebody had a will done by somebody who didn't know the APRA rules, and they said, I want to leave this much to my spouse, and the judge says, hey, we're going to turn that into a life estate. The non-Indian can say, well, I'll give up my interest, and I want it to go to our son.
Yeah, they can do that. They can renounce their interest. That non-Indian can renounce that right at that time. So I do want to talk about real quickly, there's a lot of crazy things that do happen. Even kind of in the will that you talked about, I'm not saying that's crazy, but there are efforts by people to try to will their land to somebody who doesn't meet this list, meet the list of who you can will your land to.
That's how we get our cases going.
And yeah, and I just want to tell you about one case where we did have a man, and it's a public case, I'm not going to use names, but he was at Fort Berthold, and he was a man who was very vulnerable. He was in prison, and he was also a paraplegic, he was an amputee, a double amputee, but he was in prison and at Fort Berthold. And while he was in prison, he inherited a bunch of land, and then right soon after, there was big oil development over there, and he became very, very wealthy. So with his money, he hired a law firm to do post-conviction relief to get him out of jail for whatever his crimes were. So they were successful. They were a big legal team. They were able to get him out, and he gave them authority to access his IAM account. So they picked him up at prison in a limo.
When he got released.
Right when he got out, they hired a limo, and they picked him up, and they loaded him in, and he was so happy and so relieved to be out of jail, and they took him to another city, and they had another law firm set up, and they had him do a will.
Yep, they picked him up straight from the date of his release and drove him straight to there.
And they had him do a will and will his land to them, and will the land to the attorney and the paralegal, and there was three of them. And he had a lot of land that made
Office
lots
manager?
of money. Huh?
The office manager?
I think it was the office manager or something. Anyway, so they took care of all of that, and he signed everything. He signed all of that and signed everything, giving these people his land, and then they loaded him up on the airplane.
With his money.
With his money, they got more money out of the IM account, and they went to Vegas. And they all partied around in Vegas, and then they bought a condo.
With his money.
With his money, and they were all there. And then they left him there, and they went back to North Dakota.
And they put the condo in their names.
They put the condo in their names. And then they left him there, and they went back to North Dakota. 14 days from the day they took him out of jail, all this stuff happened. He died in the condo in Las Vegas. And at that time, I was representing Fort Berthold. And there was a huge dilemma about even getting the body home, even how do we deal with that. I mean, just right from the get-go, it was a big deal. Anyway, we finally dealt with that, and then the tribe said, we want you, the tribe, we have an interest in setting aside that darn will. We want to get rid of that will. I don't know, that took us about 3.5, 4 years, but no, and they didn't even turn him into the bar. And here we get threatened to be turned into the bar when on the radio. No.
Off video.
Yeah, so what happened though is we went to court, and they had a big law team. They had all these lawyers, and on the other side was me, Georgette, and we were like,
And then his sister got a lawyer. didn't she?
then he did have a sister and a brother. They got lawyers, and so we had this huge mess. What did it come down to? The judge finally said, I am going to dismiss this, set aside the will, and why? Why? It's this list this beautiful list right here that they were not eligible devisees in a will for Indian land. And they weren't a spouse, so he wasn't going to consider any of this, you know. And he also said Fort Berthold is an IRA reservation, had it been a spouse. So the judge limited this life estate to only a spouse in that case. So we were able to set the will aside. He died as if there was no will. He had 2 siblings. So they took the money and land.
And I don't want us to get off on too much of a rabbit trail, but there was lots of information and pleadings on undue influence. That was not the only argument we made. We talked, so the pleading of why it should be set aside talked about how vulnerable he was, how they took him out, how soon he died.
The judge didn't set it aside on undue influence, which we thought was stronger, huh? Well, that's, you know, yeah, that's the risk in the probate courts. It really is. I thought the stronger argument was they took advantage of him. He was vulnerable right from the get-go. But the judge hung his hat on this list rather than undue influence. Yeah, because those are the 2 ways that you challenge a will. When a will is drafted, there are 2 ways to challenge a will. If you're not happy with the will, the first is undue influence, or second, and then the other is mental competency. Those are the only 2 theories. Nothing else is gonna, you don't waste your time on all those other things on that will. Yes?
All the things that we've been talking about, do they only go over allotted land, or is tribal land assignments or exchange assignments covered by the exact same rules?
Well, a tribal land assignment would not be a vested interest. So it wouldn't be in the inventory. So it would not apply to an assignment as far as we understand. If you do an exchange with somebody and you take that ownership, you have a vested ownership in the exchange, you know, if you 2 traded land with each other and they actually changed who owns the land and it's in your inventory, then that's where you'd be. You know, there is an inventory. You all should get your inventory. Go down to the BIA and say, I want an individual trust inventory and I want to see what I own. And you can get that. Okay. And we actually have some of that info later. All right, so let's keep going here. Oh, here's another good one. Before the law, you couldn't give up your inheritance. You couldn't renounce, you couldn't do that until 2004. And I'll tell you, so my father died in 2000. That's before this law, here at Oglala. And I have 2 half-sisters. And they grew up around here. And so I thought they should have the land from my father. I thought, well, I got adopted over at Crow, and I have land, and so I'm going to give these 2 sisters of mine my land. So I called over here to VIA. I said, I'm going to inherit land from my father, Robert Hawk, and I want to renounce it. I want you to take it and give it to my 2 sisters instead. And they said, no, the law doesn't allow you to do that. What we will do is treat you as if you died, and then we'll give those shares you had to your children. And I said, well, that defeats the whole purpose. That defeats the whole purpose. So I kept my dad's land. I couldn't do it. Huh? I might have been able to gift it. Yeah.
Once you got it, though. You'd
Yeah,
have to
once I had to get it, though, first. And then when I got it, I kept it. Yeah. But anyway, the law changed that. Now you can do that. Now you can renounce whatever you're going to inherit in favor of another heir. So that's what renunciation is. Okay, then next we'll go on to purchase at probate, or do you want to?
Just real quickly, and you can actually, when you get that interest, you can renounce it, and you can renounce it also in the same way as a gift deed. You can renounce it retaining a life estate. So, so my mom's will is in probate. So I can, at the probate, I can say, I'm going to renounce my interest in favor of my son Edison, preserving a life estate. So then my interest will go to me for a life estate, and then it'll go to him, and
In a
then
vested
in a vested interest, so the next time when I pass away, it doesn't have to go through probate again.
There's a lot of tools you can use when you go to probate. When you get into that probate hearing, there are things that you can do there. That's what we're trying to help you understand.
I do want to say, because we've had people who like to change their minds when they write a will, a renunciation and a gift deed, once you do those are permanent. Like with a will, you can write a will, and let's say I write a will, and my son's really ornery, and I get irritated with him, and I decide to disinherit him, and I say, I have 2 children, and I'm just going to leave it all to Emmy, the perfect child. Don't listen to the radio, my children. I can change that. Like the next day I can change my mind. Once you do a gift deed, you can't change your mind. You've given it. It's a done deal. So if I gift deed and I get crabby at them, that's too bad. They own it.
Yeah, and changing a will, we've been through that. Oh my gosh. So people come in and they do a will, and maybe they have an inventory that thick. And then they'll say, come back in and say, I went to this dinner and that one wouldn't even look at me or talk to me. And so I've had it with her. I need you to change that will. And so that can be a really big dilemma. You have to think about that.
But that is a tool you still have in a will that you don't have in a gift deed. So as lawyers, we do want to make sure people know, once you do a gift deed, you can't change your mind, because we have had people who've done gift deeds and then said, oh, wait a minute. And it's like, oh, no.
Okay, this is where you purchase at probate. This doesn't happen very often, but you do have that right. You can try to go to the probate, and maybe you have a brother that you're going to inherit with, and maybe you can say, I want to buy you out here at probate. There is that opportunity that you can do that. It has to be for fair market value, and they do have to consent. But you can do that, or you can buy out other heirs if you want to. If you have the finances to do that, that's possible. I actually think the better way to do this is to do a settlement agreement.
Yes, because
the settlement agreement, you don't have to worry about value. You can just all exchange. If you want to pay something over here, you can do that. But you can do a settlement agreement, and there's not a fair market value requirement. If you do this at probate, there is a fair market value requirement. But
that's what makes it hard.
a lot of times, these interests, maybe they're affordable. Maybe there's a way to do that. So this is another tool you can use for consolidation.
The challenge with this is the fair market value and how to determine that, because like Major was talking about, if it's a higher cost, it's a bigger expense. But on these smaller pieces, your appraisal may cost more than the actual parcel or the share. And so I think that's why you don't see more purchase at probate, is that fair market value is it's expensive and hard to get to.
Well, I think our cue is when Lisa needs to go to smoke, we'll have a break. So let's have a little break. We can have a short break.
10 minutes?
10 minutes, and then we'll wrap up. Okay, all right. So let me take a picture.